Namaskar, myself Deepak Kumar Rath. I welcome you all to the digital media of Uday India. Friends, have you ever seen a court appealing another court for its rights? No. But this is what is happening in this country. Even the courts are not safer anymore and are pleading to Supreme Court to save them. Imagine. Yes, this is the reality. Let me tell you how all this has transpired. The Waqf Masjid High Court and the UP Sunni Central Waqf Board filed a special leave plea with the Supreme Court of India on 13th March, challenging the High Court's decision to remove or demolish the mosque from its grounds, and the appeal was categorically denied. The administration of the mosque was given a 3-month extension to leave the premises by the bench of the Supreme Court, made up of Justices Mr. Saha and C.T. Ravi Kumar. The mosque is situated inside the High Court premises. The bench further stated that the authorities will be given permission to remove or demolish the construction if it was not taken down within the allotted 3 months of time. The petitioners were also given permission by the court to offer a suggestion to the UP government for an alternative neighboring piece of land that the state may take into consideration if the law allowed it, and if the lands were not needed for any current or future public purposes. Mr. Kapil Sibal, a seasoned advocate, spoke on behalf of the mosque committee. He requested a different location and maintained that the mosque had been there since the 1950s. For the UP Sunni Waqf Board, Senior Attorney Indra Jaisingh claimed that although the mosque was initially constructed privately, it was afterwards dedicated to the general public and registered with the Waqf Board, making it a Waqf Board property. Mr. Sival, on the other hand, disclaimed the claim that it was a Waqf mosque. Friends, what is interesting to note here is that what Senior Advocate Rakesh Dwivedi, appearing for High Court, said in the court. He said, I am quoting, "Twice there were renewal applications and there was no whisper at all that the mosque was constructed and it was used for the public. They sought renewal, saying it was needed for residential purposes. The mere fact that they were offering nawaz will not make it a mosque. If nawaz is allowed for a convenience in the Supreme Court veranda or High Court veranda, it will not become a mosque." Unquote. Mr. Dwivedi added that the mosque administration got it registered with Waqf Board in 2002 with the aim of stalling the eviction, and he argued that unnecessary religious color was given to the High Court judgment. This is the condition of High Court of India, which has to appeal to the Honorable Supreme Court to safeguard its own land. Imagine We have already told you how Waqf has become trying to turn its holy land into Islamistan. For the unversed, in essence, a Waqf is a piece of land owned by a religion. And if a property has been utilized for religious or charitable purposes for a long time, it may be considered Waqf. Once a property is recognized as Waqf, the Waqf board is in charge of it. The Waqf board has been charged with acquiring public lands and areas and turning them into Waqfs. When mosque or mazar is built and used as a place of worship, the Waqf board has the authority to designate that property as a Waqf property. Waqf board owns a huge amount of real estate, as you know. A joint parliamentary committee report from 2009 under the direction of K. Rahman Khan states that it has about 4 lakh registered properties and over 6 lakh acres of land. Just think about this. All of India's Waqf boards collectively own 8,54,509 properties distributed across more than 8 lakh acres of land, according to the Waqf Board Management System of India. It is obvious that the Waqf Board's property portfolio has increased significantly over the past 13 years. Now, shouldn't we ask ourselves the question that how did a board for minority welfare come to own such a large amount of land in this country? The answer lies, as always with the Congress, the root cause of every ill in this country. First thing first, to safeguard the Muslim properties in India, the Hindu, by mistake, quote unquote, Prime Minister Pandit Jawaharlal Nehru enacted the Waqf Act of 1954. And to appease the Muslims in the aftermath of Babri demolition, the Waqf Act of 1954 was revised by the then PM P.V. Narasimha Rao-led Congress government in 1995. Granting the Waqf board unrestricted authority. Any property that is regarded by Muslim law as being halal, ya holy, ya religious or charitable for any purpose shall become the property of the Waqf, according to Section 3 of the Waqf Act 1995. Now, according to Article 40 of the Waqf Act of 95, the Waqf Board and surveyor of the Waqf will decide whose land this land belongs to. So think before you make any decision or brand us with being Islamophobic or Congress-phobic. There is a High Court of India that is appealing in the Supreme Court to get its land back from Waqf. Imagine, this is our country. Courts in this country are regarded very highly, and even they are not spared now. Think of common man. Think of those people of a village in South India which was declared a Waqf land, even their temple, which is older than birth of Islam. Think before you do anything stupid and throw this holy land once again in the hands of plunderers, looters, and what not. This is India. And friends, you have seen how different political parties have misused exploited to appease the minorities, the Muslims, but in reality, they have not anything, any welfare for them. That's all for today. Goodbye. And I will again request all our viewers to subscribe Uday India and push the bell icon to be updated on various issues. Thank you.